What's up, everybody? I hope you had a wonderful weekend. Welcome back. I just sent a Word document in the chat. It is a midterm review guide. I also posted this under files on Cat Courses, so you can find it there as well. If you're just now joining us and you're not able to see it in the chat, let me attach it one more time, because I know that if you're joining us, you're not able to see if it was already attached. This review guide identifies concepts for review, topics for review, and then the readings that you need to review as well. And let me bring this up right now and share it with you so that we can discuss this for a moment. Okay, everybody. So I think the best way for us to do this is for you to open this up on your end as well, so that we can look at this at the same time. But I'm sharing this, and you can take a look for yourself while we go along. I have concepts here that include concepts from all of the different units so far, like political institutions, historical institutionalism, rational choice institutionalism, procedural democracy, legislature, parliamentary powers index, method of difference, method of agreement, and so on and so forth. Relatively straightforward. We also have topics for review. I have 4 topics here. The first is, how did the economic and social changes in early modern England affect politics in that country? Second, explain and assess the claim that strong legislatures promote democracy by comparing cases of strong and weak legislatures in the Americas and/or Eastern Europe. Number 3, discuss the arguments both for and against the following statement: parliamentary government is more democratic than presidential government. 4, what are the political implications of the emergence of judicial review? Is judicial review a threat to democracy? Why or why not? And then I have a list of readings here: March and Olson, chapters 1 through 3 and 6 through 7 of the Leiphardt book, the Kaiser and Barzell article, the Cox and Morgenstern article, the Ginsburg article, or the chapter, and then the news article from The Economist on November 8th of 2018. This is the material that the midterm will be drawn from. And the midterm will consist of multiple choice and short answers. Now, we have a short exam period. It's only 50 minutes. It's the duration of the class meeting. And so it has to be a short exam, and it will be a short exam. But that being said, you need to know that the best exams will demonstrate knowledge from the reading. It is not sufficient to simply recycle ideas from the slides or the lectures. You need to demonstrate knowledge from the reading. The best exams will bring insights, examples from the reading, and will demonstrate an understanding of those readings. And the responses will be more sophisticated and tactful as a result. So if you've been completing the reading on time, you're probably in great shape. Although I encourage everyone to review the reading in preparation for the exam. If you're an individual who has yet to do the reading, be prepared to read that reading and use that reading in your responses on the exam. It simply is not acceptable to write an exam that doesn't demonstrate knowledge from the reading if you want to do your very, very best on the exam. And so I'm just being realistic. I think that this is a useful way for us to prepare, but you also should know that this is all fair game. So if this list of readings is here, it means that anything on there might show up. Same with the topics, same with the concepts. But then again, I do realize that this is short, so I want you to keep in mind that it can't be too overwhelming, and it won't be. It'll be a short exam. It's just that I want you to demonstrate knowledge. No problem, Kimberly. I'm happy to help. And I want you also, everyone, to to be focused in the way you prepare for the exam, right? Sometimes with an exam, there's so much information and so much material that you don't know where to begin. And I always thought that that was a missed opportunity when I was in your shoes, when I was a student as an undergrad, because I always thought, why not help them to focus on the material that might be the most relevant, especially if they only get one chance on the exam. So my promise to you is that if you prepare for the exam by completing this, you'll be in good shape. You'll be in good shape. If you don't complete the review guide, it'll be more difficult for you to do well, or at least to do as well as you want to. Um, we'll have more questions about the exam, I'm sure, as we prepare for Friday, and I want you to feel free to ask those. We'll probably address some of those questions on Wednesday as well. But at this point, I'd like to open it up to anyone who has a comment or wants to make an observation, or if anyone has a question about the exam. Efren says for the topics for review, there will only be one short answer that we have to answer, right? I'm not going to tell you how many short answers or how few there may be. What I will tell you is that they're not essay prompts. And when I give you these topics for review, what I really intend for this to be is sort of like a one-stop shop for review. And what I mean is if you address these 4 topics and you outline responses to these, you'll be prepared to answer any number of questions that I might ask you. Though I give you 4 topics here, I could easily create, probably more than a dozen short answer questions based on these different topics. I won't give you anywhere near that many, don't worry. But my point is that this covers all of the different material that we addressed. So if you can address these topics as you review, you'll be in a good position to write about any potential short answer prompt that I give you. And so with that in mind, just realize that you're unlikely to get one of these prompts. It's more likely that I'll give you something that's a little bit smaller, but that would require you to essentially have prepared something along these lines. These are basically more like essay prompts, but you can break an essay prompt up into smaller parts if you want, is my point. Are there any other comments or questions about this? The way the exam will work is I'll post it at the beginning of the class time. Between you and I, usually I post it a little bit early because I can, and you'll have the duration of the lecture meeting time to complete the exam, and you'll have to submit it through the assignments tab on CAT courses, and there'll be a little portal that you can click and attach it. But I'll make sure that everyone has it and that you have more than enough time to complete it. And I'll make sure that it's a reasonable exam that doesn't overextend you while still challenging you and still testing you in your preparation in these different areas. Okay, everybody. So I know that there will be more questions about this as you go along. Feel free to contact me with any of those, and then we can also address those on Wednesday too. Okay. So we're addressing the judiciary now, and this is sort of fun because, full disclosure, I don't know that much about the judiciary. When it comes to democratic institutions, the courts are probably the ones that I know the least about. And so I have a lot of interesting questions of my own. And as I've prepared this lecture and as I've been thinking about some of the issues, I've been thinking about the big picture and, what kinds of questions do we need to address to understand the role of the judiciary in a democracy? What are the limits to judicial power or independence? What is the responsibility of the court in a democracy? And when have they overstepped their boundaries? When have they failed to fulfill their role? These sorts of questions. And luckily for us, in comparative politics, the newest literature on the judiciary is still relatively new. It's a new literature, and we're still learning about how courts work and how they affect democracy. And interestingly, there's a lot of really vigorous debate and a lot of normative debates about what we should or should not do, more so than in other areas of discussion about democratic institutions. And so, in light of that, I'm going to be incorporating you as much as possible because I think that there are some really deep questions about the role of the judiciary in a democracy, about the limits that I discussed, about the boundaries and where they are and when they've been overstepped. And I think that in particular, there are real important questions about the principle of election and who has the power to make decisions democratically in the ways that we've defined democracy. So please be engaged. As always, be prepared to join me and pick up the thread where I lay it down. We're always interested in the conversation in here, and I learned as much from you as I do from preparing for the course. So please be a part of it and just always ask questions and comment if you want to. I think that the best place for us to start is to look at this picture. Many of you maybe recognize this. This is the Supreme Court. And you'll immediately notice like how monolithic it looks. Look at the pillars, so gigantic, as if supporting such a omnipotent thing, this massive force. And for me, like it's sort of a metaphor for how the Supreme Court has sometimes seemed to be above the other institutions, either because it placed itself above the other institutions or because, someone or some group argues that the power of the Supreme Court is total and monolithic. And really, some of the most important discussion and debate about the role of a court and democracy engages this question of whether or not the court is above the other institutions and whether it's the court who sort of has the ultimate say, or if that is a false notion, if that's incompatible or compatible with our understanding of democracy. And this is a useful starting point for us because we're immediately thinking about responsibility and power relations and who can do what and who has the power to say yes or no or to reject or annul or review the decisions made by other institutions. We think about the checks and the balances and the separation of powers that characterize the institutions and their relationships. And maybe most of all, we think about whether any single institution does have more power than any other institution and whether or not a court might be that institution. Our definition of the judiciary in this class is going to be as follows. It is the system of courts that adjudicates legal disputes and interprets, defends, and applies the law in legal cases. And the judiciary is basically a dispute resolution mechanism. It's the sort of neutral arbiter, right? The referee, if you will, or at least in theory, it's supposed to be. It's supposed to be that referee or that arbitrator of differences, the mediator, if you will, the one who sort of dispassionately interprets and applies the law, the one who splits the baby, as they would say, the one who decides who wins and who loses or who gets what when there's a disagreement, be it civil or legal or whatever. And courts have a lot of different roles when it comes to resolving these disputes. They have a civil role, they have a legal and a constitutional role. And we have different types of law that become relevant when we consider the different kinds of disputes that courts resolve. But one overarching principle that tends to apply to all democracies and tends to be indicative of democracy is the notion of the separation of powers. And under the separation of powers, the judiciary interprets and defends and applies the law that is passed and approved and implemented by the legislature and the executive. Now, many judiciaries, many courts have the power to change laws through judicial review. And this is a power that is often viewed as over and above the original interpretation, defense, and application of the law that courts were given the responsibility to oversee. And so judicial review is one of the first starting places for us as we think about the powers of courts, the powers of the judiciary, and their different responsibilities, and how the powers of the judiciary align with the responsibilities of other institutions. You'll see that judicial review really becomes sort of a battleground, if you will, and it's a battleground over the precise power of the court in relation to the other branches. Now, under the separation of powers, this is what the model looks like. You know, we've got the judiciary on the one hand. The judiciary embodies the power to make judgments, interpret and apply and defend the law. The legislature has the power to make and change law. The executive has the power to design and implement law. The separation of powers implies a sort of equality or a set of checks and balances that exist between these institutions. And they have powers that are separate and that stand alongside those of each other. And in this regard, they can check and balance each other, but they do so under and in the context of a constitutional framework that establishes the boundaries for acceptable action. So any society has a constitution, written or unwritten, and that constitution creates the boundaries for acceptable action, what people can do, what the actors can do. And so the separation of powers theoretically exists or is meant to exist in all democracies, but the Constitution might vary and might lay out different roles and responsibilities for those different institutions. In general, though, this is our understanding of the separation of powers. When you look at this, do you think that there's any institution that stands above any of the others, or does this sort of separation of powers and this set of checks and balances create a completely level playing field? In other words, do you think that there's any institution when it comes to these three that stands above the rest? Do any of these institutions stand above the rest when you look at this, or do you see these as equal? Karen says, if the executive has the power to design and implement the law, why is it not at the top of the layout? Good question, Karen. Good question. Does anyone want to answer that question or try to answer that? Kayana says, I see it as equal. Jocelyn says, visually, it looks like the judiciary stands above the rest. Interesting. Does anyone want to take that question that Karen asked? If the executive has the power to design and implement law, why is it not at the top of the layout? And Alika says, here we go, because ultimately the judiciary gets the final say in whether or not the law is constitutional or not. Very good, Alika. Very good. And this is pretty much it, right? Even if we conceive of these institutions as having a kind of separate set of responsibilities in a kind of set of checks and balances, there's really only one actor who evaluates the constitutionality of individual laws, and that's the judiciary, right? And in so doing, the judiciary is sort of like the final arbiter. Now, you can say that technically, that doesn't mean that the judiciary stands above the executive, but it's indisputable that deciding on the constitutionality of a law that was just passed has to take place after the passage of the law, right? And so I think in terms of the process itself, the judiciary kind of comes in after the executive, as Alika points out. Alika is exactly right in pointing that out. Jeffrey says, I would say the legislative branch stands above the other two branches, since the legislative branch can change the institution of the judicial branch and pass laws that can override the laws the courts established. Boom. That's right, too. Politics got us into this, right? Presumably we have a court because we decided politically to use public authority to create one. Can't the legislature just change the rules regarding the composition and the structuring of the court itself? Yeah, right. I mean, this is what makes politics the master science. Political decision making ultimately determines everything, to the extent that everything is collectively decided somehow in society. Jeffrey's suggesting that, well, isn't it up to the legislature to just decide whether we even have a court or how independent it will be or not? Perhaps. Eduardo says, I think it's equal because even though the courts have the power to review law, they don't have the power to create it. The legislature had the power to create law, but cannot review it and cannot go through the court's judgment. Good, Eduardo. Good. That's a good argument. And you're very sophisticated and nuanced and tactful in the way that you say that, because you acknowledge that, look, the court can review law, and in doing so, it can exercise an important responsibility and a power that it can hang over the head of the other institutions, but it can't necessarily create new law, right? It can't go beyond where the other institutions already went. And in that regard, it's an equality instead of sort of like a greater power. Good argument, Eduardo. Good. Jake says, I think the judiciary does have a lot of power in the ultimate decision of whether or not laws are constitutional. If the court is too partisan to one side, laws that may be constitutional could be struck down if the justices aren't acting in good faith. So Jake's pointing out that, look, can we ever really insulate the court from politics? And, at some point, doesn't an election just become a referendum on the court when it's understood that whoever we choose for president or as the legislative majority will determine the composition of the court going forward because of the process of appointing and confirming justices? It's a good point. Jeffrey says, but at some point the playing field is leveled out since there are checks on Congress laws. Yeah, Jeffrey. And one thing to think about too is depending upon the strength of the rule of law and how strong the constitutional foundation is, it may be that it's going to be difficult for the legislative majority to cross the threshold necessary to change the Constitution, right? Or change the composition or structure of the court. They might not be able to reach the supermajority. There might be constitutional limits on what can be done that ultimately help to protect the role of the court. We'll talk about the example of Chile this week, and that's an example of a country where the Constitutional Court has both the power of judicial review as well as a position that's relatively insulated from politics because of the supermajorities required to change the composition and structure of the court. So as Jeffrey suggests, and as I agree, politics can change the court, but there are often very sharp limits to what can even be done politically. And so the court is often insulated from some of these changes. And so sometimes those justices can be more protected than they are in other cases from the political consequences of maybe their activism or the decisions that they make. Alika adds, I think they are all equal in the sense that they have their own specific roles and checks and balances. So here wouldn't be one branch without the other. So it sounds like Alika would agree that since the court can't actually they can't actually create law. They can review and potentially strike down law if it's found to be unconstitutional, but they can't go beyond what the legislature and the executive did, in the sense that they can't create law outside of that domain that they're already reviewing. And so in that interpretation, there is a lot of equality. You know, I'm really happy to see, everyone, that you're picking out different arguments for and against the argument that there's a separation of powers and a true equality, a true set of checks and balances. I'm glad to see this, because depending upon how we interpret the situation, we could make each argument. And I'll say one more thing to this. Jeffrey says, the court is powerful to rule whether a piece of legislation or executive action is constitutional, but they're not too powerful since they do not have the power of the sword or the power of the purse. Touche. The power of the purse is important, and the power of the sword is the monopoly of violence, right? And you know, it was Mao who said that true political power is expressed at gunpoint, and by that he meant that it's the military in a political system that really has the political power. To the point about the power of the purse, certainly the legislature makes decisions about how to spend money. But remember that the Supreme Court, like in the United States, can also make decisions that overrule or strike down decisions made by the legislature. So I'll give you the example of the individual mandate under Obamacare. The Supreme Court ruled that the individual mandate is unconstitutional. Or if I'm not mistaken, so forgive me if I'm not remembering this correctly, but if I'm not mistaken, the court allowed the executive branch to discontinue the penalty for not complying with the individual mandate. And the reason was because it was decided or determined that that power was within the power of the executive. My point is that courts can make decisions that either uphold or even strike down a direction of public policy chosen by a different institution. And so there are real questions to ask about what we mean when we say an equality or a set of checks and balances. You know, if the court can strike down legislation and in doing so make a decision that carries very large political consequences, you know, does that not constitute a change in law? Is that not effectively governing, in the sense that you're making a change in a decision that was going to affect everyone in society and that will have very large consequences? You know, it depends on how we view the role of the court and what the appropriate place of the court in a democracy is. And as you look at this figure, there are real questions about whether the judiciary is at the top because it is the ultimate arbitrator, or because it simply is the one that's closest to the interpretation of the Constitution. You know, you can disagree on how you view this. So when we talk about the politics of judicial independence, and when we talk about the judiciary, we really want to talk about how other actors are responding to the judiciary, and in particular in specific areas that are of interest to the judiciary or that matter to the judiciary. You'll remember that when we talked about the legislature, we conceived of the strength of the legislature in terms of institutional capacity the power of the legislature to make its own decisions about its organization, control of its resources, etc. We think about judicial independence in a very, very similar way. And in particular, we think about it in terms of the ability of the judiciary to act autonomously or independently of other institutions with regard to the court's personnel, the case selection, the decision rules, the jurisdiction, and the enforcement of laws. Generally speaking, the greater the level of input the other political institutions have regarding these different dimensions, the less independent the judiciary is. Now, by contrast, the lower the level of input the other institutions have, the more independent the court is. And so personnel is going to relate to questions about who justices are, who the members of the courts are at different levels. Case selection is going to refer to how and under what circumstances the judiciary or the court takes different cases. Why do they take those cases? Do they take those cases because they choose to take them? Or do they take those cases because there are rules in place that require them to take them? Or because other institutions in some way or another dictate their choice of case selection? What about the decision rules and the rules around the decisions that they make or the conclusions that they reach as a body? Are those rules the product of their own internal deliberation or their own process, or are those rules handed to them or given to them or imposed on them by other institutions? What about the jurisdiction of the court and its freedom within its jurisdiction and the size of its jurisdiction? And then finally, the enforcement of laws and the precise interpretation of laws. All of these are different dimensions or domains where we can observe the independence of the judiciary. And in particular, we can interpret and observe the independence of the judiciary relative to the executive. The reason that we focus especially on the executive is because executives often have more influence over the judiciary than the legislature. Power is more concentrated in the executive, as you know. It's also the case that the executive often appoints, with Senate or congressional or legislative confirmation, the top justices or the justices at different levels of the judiciary. And there also are political reasons that relate to the informal balance of power, say, between the legislature and the judiciary. And so we'll talk in coming days about how courts and judiciaries can have varying degrees of independence based upon how much input the other political actors have. And before we continue, let's just try to visualize how we would array the different types or the different forms that judiciaries would take based on the level of input from other actors in the resulting level of judicial independence. And so, generally speaking, as a reminder, then we expect to see an inverse relationship between input from other actors and judicial independence. And so, where input from other actors is very, very, very high, independence is going to be quite low. And so that's quadrant here, this first quadrant, where input from other actors is relatively low, judicial independence is going to be much, much higher. And that's this quadrant here. On the other hand, there might be low input and low independence, or high input and high independence. Those would be very unlikely or less likely based on our understanding of the relationship between input and independence that we've discussed so far. But you could imagine that those different judiciaries could be placeable in these two different quadrants. Those less independent judiciaries would be here, and those more independent judiciaries would be right here. Now, before we continue, do you think that the US Supreme Court represents a independent judiciary or on a dependent or a less independent judiciary? Jeffrey says independent. What do the rest of y'all think? Kyrie asks, independent as in separate from other institutions. Well, just as in terms of if we're thinking about independence in terms of input from other actors, do you think that the U.S. Supreme Court is sort of dependent on the input from other actors, Kyrie, or do you think that the U.S. Supreme Court is mostly kind of autonomous and independent of those other actors? Jake says, I think I would say more independent. Yeah, Kyrie, absolutely. Can make their own decisions. That would be one way of thinking about it. Justin says, I think they are more independent. Kyrie says a little bit of both. I think public opinion goes into some decisions, but for the most part, the judicial branch is independent. Kayana says, independent, especially because of judicial review. Giovanni says, the most two recent justices, I would say, have had a certain loyalty to Trump and the Republican Party, but I would say they're generally independent. I think that your analysis, everyone, is spot on. It's kind of nuanced, right? For the most part, independent, certainly with regard to judicial review and sort of autonomy and freedom to take up cases of their own choosing. But it's also evident that there's been some politicization of the bench, and in particular, and really, frankly, how could there not be when presidents appoint and the legislature confirms the top justices for life, and when, especially as has happened recently, a single presidential administration is able to appoint like a third of the bench because of a set of flukes, in the sequential death of like several justices. The sheer politicization of the process means that to some degree the court is less independent. If you assume that those justices appointed by that administration might be less capable of breaking free from that administration. On the other hand, the Supreme Court has weighed in on the supposed irregularities in the November election, and they came down conclusively on the side of it was a clean election. They also, if I'm not mistaken, I think that they ruled on that. They also ruled on the District of New York and whether or not it can obtain Trump's tax records. They ruled on other issues that related to Obamacare and the power of the federal government to enforce certain rules. And so, you can see examples of judicial independence and examples that seem to strike at maybe that relationship of dependence that we might suspect would exist because of Trump having appointed those justices. You can see then that it's nuanced, right? It seems to kind of depend. And at the end of the day, we might not be able to say much about why they're making the choices that they make, but we'll see in a moment that the question of judicial review is an issue that needs to be considered closely so that we can understand all the implications for democracy. Justin says, would actors also accommodate for the prior cases that the Supreme Court used to make their judgment based off of? If it does, I think that there also can be a bit of both. So certainly the judiciary makes decisions partly based on their interpretation of existing law, and case law and their prior interpretations matter, but that doesn't necessarily bind them to that interpretation. And so I think that there's a little bit of leeway and some room for maneuver. But I think that for this issue, the main issue is what are the relationships between the courts and the other institutions, and sort of apart from, the sources of law and how different sources of law might be interpreted differently. Jeffrey says, we have studied in judicial politics that when the president appoints a Supreme Court justice, the justice does not all the time rule in the favor of the one who appointed them. Yeah, absolutely. Absolutely. And, you know, there's a lot to this. And without getting too away from the thread here, you got to remember that justices are political as well. Even if they recognize their power to review existing law and strike it down, they also know that their decisions can have very large political consequences. And they're aware, for example, of the possibility that they might unintentionally provoke an opposition party to push through changes that result in the packing of the court and the recomposition of the court along more partisan lines or along different lines. And so whenever a court or a judiciary or a set of justices makes a decision, sure, they're thinking about the constitutionality of the decision, but they might also be thinking about the politics. And those brazenly political decisions might come back to haunt them if, for example, the next election ushers in a legislative majority and an executive that can push through changes to restructure the court and potentially, make life more difficult or shorter for that judge or that set of justices who made decisions that were antagonistic to some political actor. So I think that there is a role for politics and for political considerations in the thought processes of judges, even though we think of them as dispassionate arbitrators and arbiters of the law. On the topic of the politics of judicial review and judicial independence, there are two kinds of court actions to which political actors respond. And so I just identified those different dimensions, those different areas of judicial independence, those different areas where other institutions, the executive and the legislature, may have more or less influence, and where the influence of the other institutions may undercut the independence of the judiciary. On top of that, we add two types of actions or undertakings that can provoke a response from other political actors. And these are, first, statutory judicial review. This relates to reviewing administrative law, agency decisions, and lower court rulings. And then second, constitutional judicial review. And this relates to reviewing existing law and legislation and bigger pieces of law that go beyond administrative or case or rulings. So statutory judicial review is where courts determine that actions by regulatory agencies or rulings by lower courts are unlawful. This is the kind of judicial review that you probably hear of most often. This is where you hear about the Supreme Court taking up a case that a lower circuit court or a lower court took initially and made a ruling on. You hear about a circuit court taking a case that a still lower court made a ruling on, and so on and so forth. This is fairly common. This is the bulk of judicial review. And those instances might also review administrative law or agency or executive law, decisions made within the executive branch and made by bureaucracies or agencies at a lower level than, say, the legislature or the federal government. These are rulings and laws that we distinguish from, say, constitutional law or statutory law. In general, we can distinguish between a number of different types of law. And in order of importance, we can distinguish between constitutional law, statutory law, administrative law, and case law. constitutional law is the most important, and it's the highest source of law. You saw in the figure that I showed a moment ago that constitutional law creates the umbrella for all of the different actors. Statutory law is made by the legislature. That falls just below constitutional law. Administrative law is created by executive and bureaucratic agencies. That falls below statutory law. And then case law is essentially made by courts, made through decisions or interpretations of existing law. Case law is the lowest level, but it can be quite influential because it's part of judicial review, and it helps to legitimate or justify judicial review. And so when we talk about law, sometimes what we miss is that there are many, many layers and many sources of law. It's not as actually black and white as we think. There's actually a lot of interpretation and wading through that goes into figuring out what source of law is most relevant for this particular decision. Now, the second type of judicial review is more important and is bigger in its stakes and its consequences than statutory review. And this is constitutional review. Courts can actually be empowered to rule on the constitutionality of law itself. And so basically primary legislation, like legislation created by the legislature. This is much weightier because the political consequences can be very, very sizable and very substantial. So I gave you the example of Obamacare. The Supreme Court has ruled on the constitutionality of Obamacare many, many, many times. And it's been very, very close to striking the entire law down, but it has continually held up or upheld the law primarily because of the court's interpretation of the legislature's or the executive's power to tax. And this has been a controversial interpretation of a defense of Obamacare, but basically the constitutionality of Obamacare has been closely associated with the government's power to tax. But the judicial review process itself is what made the survival of Obamacare so uncertain, and why the strength of the Supreme Court and the power of the Supreme Court to intervene is so extraordinary, and why judicial review is so potentially explosive in its consequences. And furthermore, what's important to note is that in most countries, constitutional review is actually given to a court that is separate from the regular judiciary, and it's meant to be more autonomous. In the United States, the Supreme Court essentially exercises both forms of judicial review. In other countries, like Chile, I'll show you in a moment, they do have a constitutional court, and this is one that is separate from the rest of the judiciary, and it's set up to be more autonomous and more impermeable, if you will, and it's supposed to be more separate from the other institutions for precisely the reasons that we discussed, because of the tendency for those other institutions to exert influence or have input over different dimensions of the court's functioning and operation. And so through judicial review and through constitutional review, courts can annul laws when it finds them incompatible with a higher norm, like primary legislation, the Constitution, treaties, international law. And so what's amazing is that even in a situation where the court can exercise what is essentially ultimate authority to strike down existing law, it itself is still sort of referring to existing law. It's justifying its decision to strike down existing law by pointing to other existing law. And so this is why we talk about institutions as so critical to democracy, because it's layers and layers of institutions upon institutions. We have rule of law and laws that govern laws and institutions that govern institutions. And in this case, even though constitutional judicial authority is what permits the court to stand above other institutions, in effect, they also have to simultaneously legitimate that by referring to or pointing to some other source of law. And in the US, that's the Constitution, or more precisely, that's case law and existing history or interpretations of law. So I hate that we always run out of time. Give me just a moment, okay? This is the Constitutional Court. It's called the Tribunal of Justice in Chile, and this is separate from the Supreme Court or the judiciary. And judicial review, constitutional review, is a power of this Tribunal of Justice. Unfortunately, we're out of time. We don't have the time that I needed to do what I wanted today, but that's okay because we still have Wednesday. And we will pick up where we left off today on Wednesday. But thank you everyone for being here, and I'll see you on Wednesday. Have a good one.